Hi, I'm Carrie Brown, Director of the Vermont Commission on Women. We're working with Vermont's Attorney General, Human Rights Commission, Department of Health, and Department of Labor to inform Vermonters about a new law. It provides protection to employees who need an accommodation to perform their job because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth.
Does this apply to my workplace? Yes. All Vermont workplaces as of January 1st, 2018 must provide reasonable accommodations for an employee's pregnancy or childbirth-related condition.
What are some examples of possible reasonable accommodations?
There is no definitive list of reasonable accommodations. What is reasonable will depend on many factors, including size of the employer, the type of work done, the type of limitations the employee may have in performing that work. Employers and employees may have to try more than one accommodation to see what works best. Here are some examples.
Allowing for longer or more frequent restroom breaks. Allowing eating and drinking at workstations.
Providing a chair or stool to sit or lean on. Providing anti-fatigue matting on the floor.
Limiting lifting, bending, reaching, pushing, and pulling.
Furnishing compact lifting devices to lift, push, and pull items. Allowing a flexible schedule, a reduced work schedule, or flexible use of leave time.
Excusing employees from mandatory overtime. Arranging a day shift.
Providing rest breaks. Temporarily reassigning to available light-duty positions, or temporarily restructuring job functions.
Substituting safer chemicals when appropriate, for example, non-toxic cleaning.
Providing personal protective equipment for handling and working around hazardous substances. Providing time to recover from childbirth.
Allowing time off for medical appointments.
What do pregnant workers need to do to request a reasonable accommodation?
There are no magic words. Just tell your direct supervisor, human resources, or someone else in charge about what you need to stay healthy on the job.
Can pregnant workers be required to take leave, even if they can perform essential job functions with or without accommodation? No. Employers can't force employees to take leave because they are or have been pregnant, if they're able to perform their essential job duties either with or without an accommodation. Employers also can't make changes to the terms and conditions of employment based on assumptions or perceptions about pregnant workers. It is up to employees to request the accommodation they need.
What if employees can't complete the essential functions of their job with a reasonable accommodation?
Employees must be able to perform the essential functions or basic duties of their job with or without a reasonable accommodation to be considered a qualified employee. Employers must engage in an ongoing discussion with the employee to explore different options that may accommodate the employee so they can perform the essential functions of their job.
For example, it may be that temporary leave will provide rest or recovery time that will allow the employee to perform those essential functions. For most employers, finding some reasonable accommodation will be relatively simple. If, after working with the employee to try and find a reasonable accommodation, one cannot be found, termination from employment is possible.
Can employers request a doctor's note to back up these accommodation requests? Yes. If the medical note is necessary to make the determination, and if they request doctor's notes for other workers with similar medical needs.
The law says accommodations must be made unless they impose an undue hardship on the employer. What does that mean?
An accommodation creates an undue hardship if it would be significantly difficult, unduly expensive, or unworkable to put into place. Does the pregnant worker need to have a disability in order to receive an accommodation? No, but they do need to identify some limitation in their ability to do the job caused by pregnancy, childbirth, or a related medical condition. The purpose of the accommodation is to address those limitations.
Would employees not eligible through their jobs for parental and family leave be eligible for leave as an accommodation?
Yes. if the request for leave is reasonable and does not present an undue hardship. All pregnant employees, not only those eligible through their jobs for parental or family leave, are covered by this law.
Is there a certain amount of time that employees need to have worked for an employer for the law to apply? No. All employees, no matter their time of service, are eligible.
I need to express breast milk at work. Does this law cover that? Yes, and that's also covered by other laws that provide time, either paid or unpaid, and a private space other than a bathroom.
Are employers obligated under this law to provide paid breaks? No, unless employers are offering them to other workers with similar medical needs or work limitations.
What happens if an employer ignores, fires, or retaliates against an employee requesting a reasonable accommodation for pregnancy or a pregnancy-related condition? They could be held liable for damages, civil penalties, and attorney's fees. They could also be ordered to reinstate the employee and provide the requested accommodation. I belong to a union. Does the law still protect me? Yes, and the law does not take away any additional rights you might have under a union contract. I had a miscarriage, and my doctor doesn't want me to do heavy lifting while I heal. Does the law protect me? Yes. I live in Vermont, but I work in another state. Does the law apply to me? No. I have more questions. Who can help?
For private, county, and municipal employment, go to or visit Civil Rights Unit of the Vermont Attorney General's office.
For state government employment, contact the Vermont Human Rights Commission.
Sponsored by Vermont Department of Health, Vermont Attorney General, Civil Rights Unit, Vermont Human Rights Commission, Vermont Commission on Women.